Okay.
So can we start with the program, sir? 6 o'clock.
Yes, please.
A warm good evening to one and all to the webinar series of 2025. Advocates Association Bengaluru, in collaboration with Advocates Academy Bengaluru, has hosted a couple of webinars this year on different facets of law. And today also we have with us Murthy D. Naik, Senior Advocate, High Court of Karnataka with us, who is an eminent and eloquent speaker. And the topic chosen today is 28A of the search. Sir, am I audible?
Yes.
Today, sir is going to talk on 28A, Section 28A of the Land Acquisition Act. To be precise, sir had appeared before the High Court of Karnataka Dharwad bench, and this particular judgment, where he appeared for the party Miss Deepa Dilip Naik versus Karnataka Niravari Nigam. It's a reported judgment. This matter happened to be argued before Honorable Justice Suraj Govindraj, and the matter came to be reported, and the matter also got disposed on 11th June 2025. And sir would highlight on this particular section, and he would also enrich us with different nuances related to this particular section. Mr. Murthy D. Naik is no new to this forum. In the past also, he has presented many webinars, in fact, on different topics pertaining to criminal law. For a change, we have something pertaining to the land laws. Sir, on behalf of Advocates Association Bengaluru, Advocates Academy Bengaluru, I extend a very warm welcome to you. Over to you, sir.
Yeah, thank you. Thank you, Vikram. Thanks to the Advocates Association Bangalore. Am I audible?
You are audible, sir. You are audible.
Yeah. Thanks to the Advocates Association Bangalore, the president and his office bearers. In fact, as you rightly said, for a change, I thought of speaking on a different topic than criminal law. In fact, this 28A and the latest judgment delivered by the Dharwad bench of our High Court. So I thought it is a very apt topic, because land acquisition even today is a very haunting exercise. Haunting in terms of the claimants are concerned, that is the land losers. Over the period of time, the land acquisition proceedings gets prolonged for several decades. Years would be an understatement. Hence, the High Court of Karnataka has laid down certain guidelines as far as 28A of the Land Acquisition Act is concerned. Before I advert to the judgment as such, a brief backdrop about the scheme of the Land Acquisition Act 1894, which was amended in 1984. As all of you are aware, the land acquisition process commences with a preliminary notification under Section 4. Then you have award passed by the collector under Section 11. Then those people who are not satisfied with the award passed by the collector under Section 11, they can seek reference by receiving the compensation quantified by the collector under protest and seek reference under Section 18 to the Civil Court. That is the scheme of the Land Acquisition Act. The original Land Acquisition Act did not provide for Section 28A by virtue of an insertion in 1984, wherein the Land Acquisition Act underwent lot of amendments and insertions. 28A of the Land Acquisition Act was inserted. In fact, the present 2013 Act, which is known as the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 provides for Section 73, which is pari materia to Section 28A of the Land Acquisition Act 1894. So, by virtue of this 28A, the legislature thought it fit to give an opportunity to the land losers to seek redetermination of the compensation. Now, as I told earlier, a land loser who has sought reference under Section 18 of the Land Acquisition Act, his application would be considered by the reference court, that is the civil court, for higher compensation. Now, there are certain people who, for variety of reasons, are unable to seek reference within the stipulated period to the civil court. So, such people have a right to seek redetermination on the basis of an award passed by the reference court or the final court. Now, in the case of Munshi Ram, that is I'm sorry, in the case of Pradeep Kumari, the Honorable Supreme Court, which is reported as 1995 2 SEC 736, for the first time laid down certain postulates or prerequisites for entertaining an application under Section 28A of the Land Acquisition Act. And for the benefit of readers and for the sake of completeness, I will refer to the judgment of Pradeep Kumari, which has been referred to and reiterated in Hansoli Devi's case, that is the Constitution Bench judgment. The prerequisites for entertaining an application under Section 28A of the Land Acquisition Act are: 1. An award has been made by the court under Part 3 after coming into force of Section 28A. 2. By the said award, the amount of compensation in excess of the amount awarded by the collector under Section 11 has been allowed to the applicant in that reference. 3. The person moving the application under Section 28A is interested in other land covered by the same notification under Section 4.1 to which the said award relates. 4. The person moving the application did not make an application to the collector under Section 18. 5. The application is moved within 3 months from the date of the award, on the basis of which the redetermination of amount of compensation is sought. And 6. Only one application can be moved under Section 28A for redetermination of compensation by an applicant. So this was the law laid down in Pradeep Kumari's case. Later on, in Jose Antonio Cruz, the two judges of the Honorable Supreme Court doubted the correctness of the judgment in Pradeep Kumari case, which held that the first award passed by the civil court is the award to be considered. So later on, now the law has been diluted and it is well settled. It has been held that a person seeking redetermination who has not sought reference under Section 18 can seek redetermination not only on the basis of an award passed by the civil court, that is the court of first instance, but can seek redetermination on the basis of the award passed by the final court. That is, for example, if a sum of rupees 10,000 has been awarded by the reference court and that has been challenged by filing an appeal to the High Court, and if the High Court enhances it to 18,000 or 20,000 per gunta, then if the beneficiary or the state challenges it to the Supreme Court and attains finality, if the order of the High Court is confirmed, Then, on the basis of the judgment of the High Court and the Supreme Court, a person can seek redetermination. That is the law. After Pradeep Kumari's case in 95 and Jose Antonio Cruz's case, the as it was referred to a larger bench in Antonio Cruz's case, it was ultimately referred to a bench comprising constitution bench comprising of 5 judges, and the 2 points were raised for consideration in the case of Hansoli Devi, a Union of India versus Hansoli Devi, that is 2002, volume 7 SCC 273. There, the 5 judges of the Supreme Court held that a person did not make an application, the scope of the word or the connotation did not make an application, was expanded, and it was held that even if an application, that is a reference application under 18, was made and was dismissed on the ground of limitation, even then it has to be construed that a valid application was not made and an application under section 28A would be maintainable. So, by virtue of this constitution bench judgment, many were benefited. Now, coming to the case on hand, that is the case decided by the learned single judge of our High Court at the Dharwad bench. It was a case where there were a batch of petitions filed by Karnataka Niravari Nigam challenging the award passed by the SLAO under section 28A. There was another batch of petitions filed by the land loser as well as Konkan Railway Corporation. Now, as far as the case pertaining to Karnataka Niravari Nigam is concerned, that was a case where the award was passed under section 28A and it was primarily challenged on 2 counts. One, some of the awards were obtained by fraud, and second, the interest component that was payable was astronomical, which was to be attributed to the lapse on the part of the SLAO, and the beneficiary, that is Niravari Nigam, cannot be faulted with it, and hence the SLAO has to be blamed. Hence, they cannot be mulcted with astronomical interest by way of solatium, additional market value, and interest of 15% per annum. This was the two contention raised as far as the batch matters of Karnataka Niravari Nigam is concerned. Now, as far as the Konkan Railway, as far as the petition filed by Konkan Railway and the land loser is concerned, the land loser, there were two land losers. One of the land loser had filed in 28A. In fact, both of them had filed 28A. As far as the first land loser, that is Deepa Dilip Naik, is concerned, her lands were acquired for the benefit of laying a railway line. This was sometime in 1991. For some reason, she did not seek reference. She did not file an application under Section 18 of the Land Acquisition Act. Hence, after certain awards were passed and it attained finality in the Supreme Court, she sought reference. She sought redetermination on the strength of the award passed in respect of the lands acquired arising out of same notification. That is the sine qua non. After this, the 28A application was filed in the year 2007. It finally came to be decided in 2022. Even after the award was passed, Konkan Railway did not deposit the amount. In respect of the second land loser, that is Vitoba Shankar Faide is concerned, there also lands were acquired for the benefit of Konkan Railway project. No reference was sought, hence 28A application was filed. 28A application was again decided in 2022 after a lapse of nearly 15 years. Hence, both the petitioners conjointly filed one writ petition seeking a direction in the form of mandamus to Konkan Railway Corporation, saying that seeking a direction to deposit the awarded amount by the SLAO. After notice was issued to the Konkan Railway, they entered appearance and filed two separate writ petitions challenging the award passed by the SLAO. In both the petitions, individual writ petitions were filed. So all were clubbed. The writ petitions filed by KNNL and the writ petition filed by Deepa, Vitoba together for mandamus and the writ petition filed by Konkan Railway were all clubbed and heard together in writ petition number 100706 of 2023 connected with other 16 petitions. So while the main contention of Konkan Railway in as far as our petition for mandamus is concerned was firstly a writ petition for mandamus is not maintainable on the score that it is even an award passed under section 28A of the Land Acquisition Act is an executable award, hence an execution has to be filed. So on that ground, they oppose the writ petition filed by Deepa and Vitoba Shankar Faide. As far as their petition is concerned, the thrust of their petitions centered around interest mainly. The first ground was the interest payable was astronomical and they cannot be fastened with liability of exorbitant interest for the lapse on the part of SLAO. That was the main ground. Then several grounds were urged. As far as Deepa Dilip Naik's petition is concerned, the main ground was, or rather another ground was the calculation sheet that was attached to the award given to Deepa and the calculation sheet that was given to Konkan Railway varied. The calculation sheet appended to the award given to Konkan Railway was higher than that was given to Deepa. Hence, it was argued that there was review of the award, hence that cannot be accepted, which is not permissible. Hence, the award is bad so far as Deepa is concerned. As far as Vitoba Faide is concerned, the award was the award as well as the calculation sheet was common. And additional grounds were with regard to the copy that was appended to the 2080 application. Friends, as I submitted earlier, under section 28A, when you seek redetermination of an award, it has to be done within 90 days from the date of judgment. And there is a proviso under section 28A for the benefit of the viewers. The proviso reads, provided that in computing the period of 3 months within which an application to the collector shall be made under this subsection, the day on which the award was pronounced and the time requisite for obtaining a copy of the award shall be excluded. So what Deepa and Vitoba Faide had done was they had taken a copy of a certified copy of a judgment passed by the civil court, and on that basis, after the benefit of the time for supplying the copy was accrued. All that was computed and a 28A application was filed. Hence, their main contention was the application filed under Section 28A is barred by limitation because the benefit of copying time is not available to Deepa and Vitoba as they were not the applicants of the certified copy. Instead, they had taken it from another land loser arising out of the same notification. Hence, that benefit will not accrue to them. These were the two grounds. Additionally, as far as FIDE is concerned, they had argued that the award was passed against a dead person. See what had happened as far as Vitoba Shankar Faide's case is concerned. He passed away in 2021 during the pendency of the 28A application before the SLAO. Later on, an LR application was filed by the LRs of Vitoba Faide. They were brought on record. But a very strange contention was raised to the effect that the award is passed against a dead person, hence it's void ab initio. Hence, all these contentions were taken into consideration, and the Honorable Court in para 35 on page 185 of the judgment has formulated around around 10 points for considerations. I will read out I'll read them out. One, whether a land loser filing an application under Section 28A is required to obtain a separate certified copy in the name of the land loser to file such an application under Section 28A. 2. Is the period of 3 months mentioned in subsection 1 of section 28A and the proviso thereof required to be calculated from the date of award passed under section 18, enhancing the compensation, or is it from the date of knowledge of the applicant making an application at section 28A? 3. Whether the period of 3 months mentioned in subsection 1 of section 28A and the probability thereof, whether the applications filed as 28A insofar as concurrent railway acquisition matters are concerned have been filed within 90 days of the award having been passed under section 18. Whether the delay caused by SLO in disposing the matter under section 28A can be excluded for the purpose of calculation of interest on the enhanced compensation. If so, what would be the remedy available for the land loser on account of such delay? 5. Whether the period of 2 years statutorily imposed for rendering an award under Section 11A of the Land Acquisition Act 1894 would also have to be made applicable to an award passed on a reference made under Section 18 and an application made under Section 28A. 6. Whether in this particular case the delay caused by SLAO of more than a decade would require disciplinary proceedings to be initiated against the SLAO. Whether there is a review made by the SLAO of the award as contained by Konkan Railways. Whether the award passed in so far as Faide's case is an award which has been passed against a dead person. 9. Whether the writ petition in WP 103322 of 2023 by Deepa Dilip Naik and Vitoba Shankar Faide seeking for relief of mandamus as sought for are maintainable. 10. Whether the award passed by the SLAO under section 28A in the present matter requires interference at the hands of this court. So these were the 10 points formulated in both the sets of petitions. Now, as far as the first point, that is whether a land loser Filing an application under 28A is required to obtain separate certified copy in the name of the land loser. To file such an application, section 28A, the learned single judge has held it in the negative and has turned down the contention raised by Konkan Railway and has held that there is no such requirement. The proviso has been discussed. I will not go into the details because the judgment runs into around 265, 271 pages. So in paragraph 37 onwards, the first point for consideration has been answered, and it has been held that there is no such requirement of filing an application by the applicant himself. He can rely on a copy of the certified copy obtained by the claimant, in that case arising out of the same notification. So what has been reiterated is that as held by the Supreme Court in Hansoli Devi's case, it 28A being a beneficial legislation, it has to be given a liberal meaning, and accordingly a copy of the certified copy can be produced. Hence there is no requirement for the land loser himself or the applicant under 28A to apply for a certified copy and file it within 90 days, and the benefit of time spent on obtaining the copy by the applicant shall accrue to the applicant under 2080 is what has been held, and accordingly the contention of Konkan Railway that this has been applied by someone else and not by the applicant has been turned down. In fact, they had heavily relied on the judgment of the Gujarat High Court on a 97 judgment of the Gujarat High Court that has been considered. And after considering the Constitution Bench judgment in Hansoli Devi, it has been held in 37.15, paragraph 37.15, that in my considered opinion, the proviso to section 28 capital A1 would also have to be beneficially interpreted so as not to deprive an applicant under section 28A as held by the apex court in Hansoli Devi's case. The right under section 28A is a substantial right granted by a statute and would have to be given due effect to. In that view of the matter, I answer point number 1 by holding that an application section 28A can be filed by referring to an award passed under section 18 without producing a certified copy of the said award under section 18. However, by making a reference to the said award, the aspect of whether the award made in section would be applicable to the application filed in section 28A would have to be determined after due inquiry and hearing the parties and considering the necessary criteria to establish that the applicant under section 28A is entitled to the benefit of the award passed under section 18. So this is as far as point number 1. Now, point number 2 is answered in paragraph 38 onwards. That is the period of 3 months mentioned in subsection 1 of section 28A of the proviso thereof required to be calculated from the date of the award passed in section 18, enhancing the compensation, or is it from the date of knowledge of the applicant making an application under section 28A? Now, this has been held that it is not from the date of knowledge, but it is in paragraph 38.3 on page 204, because this is yet to be reported. It's a reportable judgment. 38.3 of the original judgment. In that view of the matter, I answer point number 2 by holding that 3 months time mentioned in section 28A1 and the proviso thereof is required to be calculated from the date of award passed under section 18, enhancing the compensation, and not from the date of knowledge of the applicant under section 28A of the enhancement under section 18. Now, the third point, whether the period of 3 months mentioned in subsection 1 of section 28A and the probability thereof, whether the applications filed in section 28A insofar as Konkan Railway acquisition matters are concerned have been filed within 90 days of the award having been passed under section 18. So after hearing elaborate arguments, the learned single judge has held that in paragraph 39.17, the learned single judge has held. Hence, I answer point number 3 by holding section 28A being a beneficial provision brought in by way of an amendment so as to make available the very same compensation as made available to another land loser who had filed an application as section 18. Even if the second land loser were not to file a reference under section 18, such person would be entitled to the benefit of filing an application under section 28A on the basis of an award passed in a reference filed by one other land loser. 2. The above would be the case even if the applicant under section 28A had filed a reference at section 18. As regards any other land, it is the option of the land loser to file a reference at section 18 or not. Such a land loser can choose to wait for an award to be passed under section 18 and thereafter relying on such an award, file an application under section 28A. Insofar as the time period for filing an application under section 28A, the same is prescribed as 90 days, which is required to be calculated from the date of an award passed in section 18, excluding the time taken for obtaining a copy. This aspect would, however, require further consideration, which may now be academic in view of LA Act 1894 having been repealed and LA Act 2013 replacing it. This being so, for the reason that the limitation period for filing an application under section 28A has been fixed with reference to an award passed in a proceeding of which the applicant in section 28A was not a party, and as such there can be no presumption of knowledge of the award on the applicant under section 28A unless he or she was a party. Thus, the aspect of the date of calculation of limitation period, whether it is on the date of award or date of knowledge, would require consideration inasmuch as the land loser, having lost his or her land, would be entitled for just compensation, which could be determined by taking into account compensation which has been awarded in a similar manner. Now, in fact, in this, while answering the third point, another factual aspect as far as Deepa Dilip Naik's case is concerned, Deepa Dilip Naik had lost another parcel of land a little earlier than this notification. As far as that land acquisition is concerned, she had sought reference and that reference was answered. It traveled right up to the Honorable Supreme Court. Compensation was fixed. However, for reasons best known to her, she could not seek reference under section 18 as far as this acquisition is concerned by way of a separate notification. Hence, it was argued that the very same lady who was a land loser and who was a claimant in the earlier acquisition proceedings has not sought reference. Hence, the benefit of section 28A should not go to her. That was the argument, and that has been turned down. Then the fourth point for consideration was whether the delay caused by SLAO in disposing of the matter under section 28A can be excluded for the purpose of calculation of the interest on the enhanced compensation. If so, what would be the remedy available for the land loser on account of such delay? And point number 5 is also answered together, that is 4 and 5. Point number 5, whether the period of 2 years statutorily imposed for rendering an award under Section 11A of the Land Acquisition Act would also have to be made applicable to an award passed on the reference made under Section 18 and an application made under Section 28A. Now, both these points for consideration were considered and answered together in after taking into consideration the scheme of the Act, that is Section 18, 28A, and all the other provisions, the court has held that in that view of the matter, in paragraph 40.41 on page 241, it has been held. I answer point number 4 by holding that the word compensation, which has been used in section 34, would include within its purview enhanced compensation and or compensation awarded by whatever name called, requiring interest to be paid on such amount. 40.42, the time spent oblique delay in proceedings before the reference court and or the SLAO, if any, cannot be excluded for the purpose of calculation of interest on the compensation or enhanced compensation. 40.43, I answer point number 5 by holding that the statutory period of 2 years, which has been fixed for passing an award under Section 11, is a salutary rule. However, as indicated supra, there is no such time period fixed in respect of an award to be passed on a reference application by the reference court under Section 18 or redetermination of compensation Section 28A. The acquisition proceedings under the LA Act in most cases having been completed and there being very few matters left for adjudication Section 18 or 28A having been repealed, there will be no purpose served now by amending LA Act 1894, which has stood repealed. It would be required for the Chief Secretary, Government of Karnataka, and the Principal Secretary of Revenue Department to issue necessary directions to the concerned, fixing timelines even for proceedings under Section 18 as also under Section 28A, so those matters could be disposed of as expeditiously as possible. 40.44, it would also be required to implement a suitable monitoring system using the necessary information technology tools to monitor the matters pending under Section 18 or 28A. So these are the various guidelines laid down, landmark guidelines in fact. Now as far as point number 6 is concerned, it has been dealt with in paragraph 41 of the judgment. Whether in this particular case the delay caused by SLAO of more than a decade would require disciplinary proceedings to be initiated against the SLAO. The learned single judge has held that I answer point number 6 by holding that ex facie it is the SLAO who is responsible for the delay, and hence the Chief Secretary of the Government of Karnataka is directed to cause an inquiry into the matter and submit a report within a period of 6 weeks from the date of receipt of a copy of this order. Hence, at one breath, that is, as far as point number 4 and 5, the argument raised by the beneficiaries, that is KNNL as well as Konkan Railway is concerned, has been turned down to the effect that the land loser cannot be faulted with. Hence, at the same time, the beneficiary also cannot be faulted with, but the scheme of the scheme of the act is such that they are entitled to compensation irrespective of delay in deciding the application, because the land loser nor the beneficiary can be faulted with. Hence, it has been held that interest is payable right from the date of acquisition till the date of payment. N- However, the learned single judge has held that ex facie the SLAO is to be faulted with, hence disciplinary inquiry has to be initiated against him. Now, as far as point number 7, whether there is a review made by the SLA of the award as contended by Konkan Railways. Friends, as I submitted earlier, the learned senior advocate for the Konkan Railways had argued very vehemently that there is a review because there are two calculations as far as Deepa Dilip Naik is concerned. One calculation sheet appended to the award given to the claimant, that is Deepa Dilip Naik. Another calculation appended to the award given to Konkan Railway. Hence, it was argued that it amounts to review and hence the award is bad in law. On this score, the learned single judge has held that I answer point number 7 by holding that the calculation which was sent along with the draft award is not a final award. The changes made to the calculation before the publication of the final award is not a revision or review of the award. Hence, that contention also has been turned down. Now, as far as point number 8 is concerned, whether the award passed in so far as Faide's case is an award which has been passed against a dead person. As I told you earlier, it was contended that Mr. Vitoba Faide died during the pendency of the proceedings, hence his LRs were not brought on record. Hence, the award has been passed against a dead person. Negativing that contention, it has been held that, in fact, in paragraph 43.2, there is a finding to the effect that a perusal of the file indicates that the death of Vitoba Shankar Faide was reported on 24/6/22, which was recorded and the matter was adjourned to on so and so dates. On 14/10/2022, his legal ads were brought on record and the award was passed on so and so date. There was no objection made by Konkan Railway to this aspect at that point of time. The legal heirs being the beneficiaries of the application filed by Vitoba Shankar Faide, the documents and the details which have been placed on record by Vitoba Shankar Faide have been taken into consideration. Since the legal heirs did not lead any further evidence, therefore the question of Konkan Railway leading any further evidence or being aggrieved by them being brought on record would not arise. 43.3, the award having been passed on 17/12/2022 is much after the legal heirs having been brought on record. Therefore, it cannot be said that the award is passed against a dead person. Now, as far as point number 9 is concerned, whether the writ petition filed by Deepa Dilip Naik and Vitoba Shankar Faide seeking for a relief of mandamus as sought for are maintainable. This is a very important point for consideration, friends, because as I told you earlier, we've sought for a direction in the form of mandamus, seeking a direction to the SLAO to disperse the amount, or seeking the beneficiary to deposit the amount and the SLAO to disperse the awarded amount. That was objected to by the Konkan Railways, and it was contended that it is not an it is a mandamus cannot be sought and an execution can be filed. That contention of Konkan Railways has been accepted and it has been for the first time. In fact, it was a grey area. There is no ruling on this point whether an execution would lie. Execution to the civil court would lie against an award passed under Section 28A. After discussing all the contentions, the Honorable Court has held Thus, hence, I answer point number 8 by holding that the present writ petition filed by land loser seeking for a mandamus directing the beneficiary of the acquisition to make payment of the compensation awarded in section 28A is not maintainable. Such land loser has an alternative remedy of execution proceedings. Liberty to file the same is reserved. While deciding this point, the learned single judge has relied on the earlier judgment of our Honorable High Court in the case of Venkateswamy Gowda, Sheetal Jaidev Vade, Vaman Rao Kulkarni, and Pandurang's case. In fact, in 44.5 is also very important for the benefit of the viewers. I'll just read it out. There cannot be any dispute as regards the ratio laid down in Venkateswamy Gowda's case, Sheetal Jaidev, etc., etc., an award having been passed either under Section 11, Section 18, or Section 28A, unless under challenge, are executable, and the land loser would be entitled to execute the same by instituting execution proceedings, and in such execution proceedings, show cause notices being required to be issued if payments are not made or no appearance is made. The properties could be attached, brought for sale, and the amounts paid to the land user. In fact, the learned single judge has expanded the scope and has held an award under section 11 that is passed by the SLAO at the nascent stage is also an executable award, and also under the 18 which is well settled, and an award under 28A. So this, in fact, will be beneficial to all the land users because it used to, these awards passed by the SLAOs or the Assistant Commissioner would hit a roadblock. It used to be like a dead end because once an award is passed, all along writ petitions were filed, but now it has been held that it is an executable award and a mandamus cannot be. And by virtue of this finding in point number 9, that it is an executable award, there are two benefits which, according to me. One, the land loser will be entitled to up to date interest because normally these awards are passed around 2 or 3 years back. So the execution is filed until the date of payment of the actual compensation along with all the statutory benefits and interest the land loser would be entitled to. And secondly, there is no gray area as far as whether it is an executable award or not. Now execution can be filed before the civil court and a mandamus, a writ for mandamus is not maintainable. Now, as far as point number 10 is concerned, whether the award passed by the SLA under section 28A in the present matter requires any interference at the hands of this court. So this is in paragraph 45 on page 253 onwards. After considering the contentions of the learned senior advocates appearing for KNNL as well as Konkan Railway and the various case laws cited, the learned single judge has held that it is it requires no interference, and the award passed by the SLAO is final, and the land loser is entitled to execute the award passed under 28A. In fact, in paragraph 45.13, the learned single judge has observed, thus, in my considered opinion, looking at the matter holistically and taking into consideration the net effect of a remand, I am of the considered opinion that there is no useful purpose which would be solved by a remand being made to the SLAO to consider the aspect of whether the lands are similarly situated or not. the same would only result in additional litigation cost, additional interest, as also delay in the land loser receiving the just compensation for which they have been waiting for more than 3 decades. In that view, I answer point number 10 by holding that there would be no useful purpose served by interfering with the award passed under Section 28A in matters both relating to KNNL and Konkan Railway, and as such, I refrain from any such interference. Having heard all the counsels and having perused the records, I find the award passed by the SLAO to be thoroughly lacking, except for stating that there is an award which had been passed in the proceeding under Section 18, where an award has been passed and subsequent application at Section 28A has been filed. The amount awarded in Section 18 proceeding was awarded in 28A proceeding. There is no finding recorded by SLAO as to whether the lands are similarly situated, what is the distance, etc., etc. Having gone through the records, it is also not possible for this court to examine at this stage as to whether these lands are similarly situated or not, since there is no evidence which is available on record to indicate the same. And in that background, I am of the opinion that the award passed by SLO in Section 28 in the present matter requires interference by setting aside the same and matter being remitted for fresh consideration. After this, certain general directions are issued. In paragraph 46, one is the learned single judge has directed to, just to summarize, I will not read it, has held that, has directed the Chief Secretary Government of Karnataka to issue certain guidelines and a standard operating procedure. And while doing so, the Chief Secretary could also take the assistance of Principal Secretary, E-Governance Department, so as to harness the available technology to bring about transparency and efficiency in the system. Secondly, to implement a suitable software to capture the details of the acquisition, notification, inquiry report of SLAO, final notification, and or the like, that is all proceedings and documentation from the time of issuance of a preliminary notification till the final notification, including notices, file notings, etc. Third, the proceedings between final notification to the passing of the award, the details of the documents that have been considered by the SLAO, any opinions obtained by SLAO and considered, the guideline value, etc., to be all uploaded onto the said software. Four, if an application is filed in Section 18 for reference, the procedure followed by SLAO in passing necessary orders on said reference, transfer of the case to reference court, etc., etc., to be uploaded. Maintaining an electronic register in the software as regards any application filed under Section 28A with date and timestamp, the actions taken on the said application, notices to be issued to the concerned department or the beneficiary electronically by way of email, which is available on record, to consider the matter as expeditiously as possible and pass a redetermined award after taking into consideration the commonality of the land, the distinguishing factors of the land, the date of acquisition, etc. The Chief Secretary of Government of Karnataka to consider the time limit that could be fixed for SLO to consider an application in Section 18 and or 28A and to issue necessary instruction to all the SLAOs in relation thereto. Lastly, a detailed project report in regard to the above to be formulated and placed before this court within the period of 6 weeks of receipt of a copy of this order. And finally, in view of the above and in view of the answers to all the above, I pass the following. No grounds being made out by writ petitions filed by Karnataka Niravari Nigam, no grounds being made out by the writ petitioners in so and so by Konkan Railway Corporation. The writ petition filed by Deepa Dilip Naik and Vitoba Shankar Faide and others dismissed with liberty to the petitioners to approach the execution court seeking for appropriate reliefs. So this is the judgment as far as the learned single judge is concerned of our High Court. So, as I stated earlier, most of the land losers are haunted on day in and day out. So hopefully this judgment would be helpful in solving the delay. Especially, there are two types of delay. One is pre-acquisition, then post-acquisition as far as compensation, notification, dispersal, etc. So I'm quite hopeful that this judgment would be helpful to all the land losers as well as the beneficiaries insofar as the interest is concerned, instead of the crying foul at a later stage, saying that the SLO slept over the matter for 15 years and we are required to pay, all those things, I think will be addressed, is my sincere hope. Yeah. Thank you once again. I think Trivikram, you can share this judgment on all the groups.
So certainly, sir, I'll do that.
Yes,
And
because it is yet to be reported. I'm not sure whether it's reported in SEC, but it is reported in Daksha.
correct, sir.
Yes.
Otherwise, also it's already a reported judgment. So
Reportable.
reported by the
Yes.
High Court of Karnataka.
Yes.
So gradually, I think it would get a place in the reporter, Karnataka.
Yes. Yes. It will take some time. In the meantime, you
It will
can share this.
correct. Certainly, sir. I'll share that with the groups.
Yes. So
Um,
exactly
as
one
usual,
hour
sir,
I have completed.
sir, in your ardent and articulated style, you have presented the webinar. Now it's time for Q&A. So I would request all the participants, if you have any questions, you may shoot the question on the Q&A box, or parallelly you can hit the hand raise button so that I would unmute you so you can directly interact with the speaker. I see my colleague Varun is online. Arun, if you have any question, you can also post to the senior advocate. I repeat, all our viewers, if you have any questions pertaining to today's topic, you can hit the hand raise button so that I would unmute you and you can interact directly with our resource person. Or parallelly, you can send that question on the Q&A box so that on behalf of you, I would be posing it to the resource person. I think Mr. Anand L has a question. Mr. Anand, can you switch on your video so that I can unmute you? Not sure if you are an advocate. Yes, with white shirt. Yes, certainly. Advocate. Mr. Anand, I have given you the option to unmute yourself.
Yes, thank you very much, Advocate Murthy D. Naik, sir. It was wonderful knowledge as well as sharing with regard to the 2080 in respect of particular judgment is concerned. I would like to just run through after your thing. But one, apart from that particular judgment, I have one small clarification which is as such that there will be a notification with respect to same project. Those will be of or the same notification, and there will be two types of compensation is awarded. One is that consent award. The second is going to be the general award. When the general award is been passed, that anyway, the most of the time the people, the land losers will challenge it by way of 18(1) reference, and subsequently that has been decided by the honorable court, and there is an enhancement of compensation, and the final judgment will arise. So based on which, whether this first set of people who have got the consent award are eligible to file this 2080 is my guess.
No. See, once a consent award is passed under Section 11, in fact, there is a 2007 judgment of our Honorable High Court, which holds that once a consent award is passed, you cannot seek reference. So question of seeking redetermination does not arise at all because it's a consent award. But you can seek redetermination or reference under section 18 only when you have not consented, only when you have accepted the award under protest, award passed under section 11. That is the reason initially itself I had given you the flow, starting with 4-1, then all those 6-1s, etc., then award under 11, then 80. So when it's a consent award, you cannot seek a redetermination or a reference.
And thank you very much for that particular clarification. And similarly, it is the same project. When there is a same project, there will be two sets of notifications, which are very close by in a matter of 6 months or 1 year gaps. So if that's the scenario, the when first set of notification is passed and that is being challenged, and the by way of 18.1 reference, and that has been enhanced by the honorable court, and it is concluded, based on which that particular outcome judgment, the second set of the acquisition people for the same project with the different notification are entitled to use the file 28A is my point.
Yes, certainly. In fact, the law, I had mentioned this, I think you were not very attentive.
Yes, yes. I
See,
just observed that, but
you see an award. Earlier in Pradeep Kumari, the law was the award passed by the first court. That is, first court in land acquisition cases is the reference court, that is the civil court. Now it has been held that it is the final court. If an award passed by the first court is challenged in an appeal to the High Court and further to the Supreme Court, the final award passed by the final court, will be the basis for seeking redetermination.
okay. So at any
And
stage, like
it should arise from the very same notification.
okay,
Say there are
same.
100 land losers in a notification passed in the year 1991, out of which 5 of them don't seek reference. The remaining 95 seek reference, and an award is passed in respect of one of them or all of them. So that travels to the higher court. So that award can be made basis for seeking redetermination under 2080.
At the stage of the final judgment, based on which can
Yes,
be.
based on me. That is the sine qua non. You can't make use of a notification other than the very same notification. An award passed in the very same notification. Your name should be there in the same notification as that of the other land loser whose award you are relying on seeking redetermination. That is the sine qua non.
Yes, sir. Thank you very
Thank
much,
you.
Murthy.
Do we have any more questions? Sir, I have worked with you together in some of the cases, and I always felt that you are an expert in the criminal law, the area arena. But today's webinar, it's no surprise that you have flaunted your expertise on other facets of law as well, particularly the land laws. With that note, sir, once again, many thanks to you for this webinar. On a working day, you have accommodated us. On behalf of AAB and on behalf of Advocates Academy and my personal behalf, sir, many thanks to you. Before we conclude, I see somebody else also raising their hand, so we'll give them opportunity.
Yes, please.
Mr. Ziomi, I would request you to change your name. If you can just rename yourself with your real name, I would be unmuting you. You have a rename option on your system, so kindly rename with your original name so that immediately
Or they can switch on the video.
A video, perhaps that also works.
Xiaomi has left. No,
No.
Xiaomi is still there.
Xiaomi I have given you the option to start the video. Just to ensure that I'm just unmuting a bona fide Mr. Manju. He is Mr. Manju. So I have given you the option to unmute. Mr. Manju, I have given you the option to unmute. Can we do this quickly, please? Mr. Manju?
Yes, sir.
Yes, please.
Hello, sir. Hello.
Yeah, Biki ಕನ್ನಡದಲ್ಲಿ ಕೇಳಿ. If you have some difficulty, you can.
Sir. ಸರ್ ಎರಡು ಮೇಜರ್ ಕ್ವಶನ್ ಇದೆ ಸರ್.
ಹೇಳಿ.
ಸರ್ ತುಂಬಾ ಧನ್ಯವಾದಗಳು ನಿಮ್ಮ ಈ ವೆಬಿನಾರ್ಗೆ. ಮತ್ತು ಫಸ್ಟ್ ಮೊದಲನೇದಾಗಿ ತುಂಬಾ ಚೆನ್ನಾಗಿ ನಮಗೆ ಕನ್ಕ್ಲೂಷನ್ ಕೊಟ್ರಿ ಸರ್. ಎರಡು ಕ್ವಶನ್ ಇದೆ ಸರ್. ಸರ್, ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ 10 ಜನ, ಒಂದು ಉದಾಹರಣೆ, ಒಂದು ನೋಟಿಫಿಕೇಶನ್ 10 ಜನ ಇರ್ತಾರೆ ಸರ್. ಅದರಲ್ಲಿ 4 ಜನ ಮಾತ್ರ ಸೆಕ್ಷನ್ 18 ರೆಫರೆನ್ಸ್ ಮೇಲೆ ಇದು ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೋತಾರೆ. ಉದಾಹರಣೆ, ಒಂದು ಎಕರೆಗೆ 10,000 ರೂಪಾಯಿ ನಂಗೆ ಆರ್ಡರ್ ಆಗುತ್ತೆ ಸರ್. ಇನ್ನ ಉಳ್ದ 10 ಜನದಲ್ಲಿ 4 ಜನ ರೆಫರೆನ್ಸ್ ಆಗುತ್ತೆ, ಇನ್ನು 6 ಜನ 28 ಹಾಕೋತಾರೆ ಸರ್. ಅವ್ರಿಗೂ ಕೂಡ ಕಾಂಪೋಸಿಷನ್ ಸಿಗುತ್ತೆ. ಈ ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಈ ಮೊದಲು LAC ಅದು 18 ರೆಫರೆನ್ಸ್ ಆಗಿದ್ರಲ್ಲ 4 ಜನ, ಅದರಲ್ಲಿ 2 ಜನ ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ಗೆ ಅಪೀಲ್ ಹೋಗ್ತಾರೆ ಸರ್. 2 ಜನ ಮತ್ತೆ ಅಪೀಲ್ ಹೋಗ್ತಾರೆ. ಅದರಲ್ಲಿ ಒಬ್ರದ್ದು ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ, ಇನ್ನೊಬ್ರದ್ದು ಇನ್ನೊಂದು ಪಕ್ಕದ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಲೋ ಆಗುತ್ತೆ ಸರ್. ಅಲೋ ಆಗ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಮತ್ತೆ ಇನ್ನೊಂದು 10,000 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಈ ನೆಕ್ಸ್ಟ್ ಜಾಸ್ತಿ ಆದ್ಮೇಲೆ ಫಸ್ಟ್ 6 ಜನ 28 ಆಗಿರಲ್ಲ, ಅವ್ರು ಮತ್ತೆ ಪುನಃ 28 ಹಾಕಬಹುದಾ?
ಇಲ್ಲ, ಮತ್ತೆ ಅವ್ರು ಯಾರು 6 ಜನ 6 ಜನ ಯಾರು ರೆಫರೆನ್ಸ್ ಕೇಳಿರಲ್ಲ ಅವ್ರು ಹಾಕೋಬಹುದು.
ಅವ್ರು ಹಾಕೋಬಹುದು. ಬಟ್ ಈ
ಫೈನಲ್ ಅವಾರ್ಡ್, ಫೈನಲ್ ಏನ್ ಅವಾರ್ಡ್ ಆಗುತ್ತಲ್ವಾ, ಅದ್ರ ಮೇಲೆ ಅವ್ರು ಹಾಕೋಬಹುದು ಈ 6 ಜನ. ಈಗ ಬೈ ಚಾನ್ಸ್ ಈ 6 ಜನದ ಪೈಕಿ ಯಾರೇ ರೆಫರೆನ್ಸ್ ಕೇಳ್ಬಿಟ್ಟು ಅವ್ರದ್ದು ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರು ಸಹ ಅವರು 28 ಹಾಕ್ಬೋದು. ಅದೇ ಅದು ಹನ್ಸೋಲಿ ದೇವಿ ಜಜ್ಮೆಂಟ್ ಸೇಸ್ that even if it is dismissed on the ground of limitation, it is as good as you have not sought reference under section 18, 2002 volume 7 SEC 273.
Okay. SEC 273.
Yes, 2002 volume 7 SEC 273, Union of India versus Hansoli Devi.
ಹನ್ಸೋಲಿ ದೇವಿ.
Yes.
ಸರ್, ಅಂದ್ರೆ 18 ರೆಫರೆನ್ಸ್ ಆದವರು ಕೂಡ ಮತ್ತೆ ಈ ಎನಾನ್ಸ್ ಬೇಸ್ ಮೇಲೆ 28 ಹಾಕಬಹುದು.
18 ರೆಫರೆನ್ಸ್ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಮಾತ್ರ.
ಓಕೆ. ಮೈನ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಸರ್? ಈಗ
ಮೈನ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಮತ್ತೆ 28 ಕೇಳಕ್ ಆಗಲ್ಲ. ಯು ಲೆಟ್ ಟು ಫೈಲ್ ಎನ್ ಅಪೀಲ್ ಓನ್ಲಿ. ಈಗ ಯಾರು ರೆಫರೆನ್ಸ್ ಕೇಳಿರ್ತಾರಲ್ವಾ ವಿದಿನ್ ಟೈಮ್, ಅವ್ರದ್ದು ಮೆರಿಟ್ಸ್ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ, on merits dismiss ಆದ್ರೆ you have to file an appeal. ಬಟ್ ಅವ್ರದ್ದು ಲಿಮಿಟೇಷನ್ ಗ್ರೌಂಡ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ you can seek redetermination.
ರೀಡಿಟರ್ಮಿನೇಷನ್ ಮತ್ತೆ 28 ಅಲ್ಲಿ ಹಾಕೋಬಹುದು. 18 ಆಗಿದ್ರು ಕೂಡ 28 ಅಲ್ಲಿ ಹಾಕೋಬಹುದಲ್ಲ ಸರ್?
18 ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರಷ್ಟೇ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ರೆ ಇಲ್ಲ.
ಇಲ್ಲ ಸರ್, ನಮ್ ಕ್ವಶನ್ ಆ ತರ ಅಲ್ಲ. 18 4 ಜನ ರೆಫರೆನ್ಸ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಅವ್ರಿಗೆ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಫಸ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಕುಂಟೆ ಎಕರೆಗೆ 10,000 ರೂಪಾಯಿ ನಂಗೆ ಅವಾರ್ಡ್ ಪಾಸ್ ಆಗಿದೆ. ಆ 4 ಜನ ಏನ್ 18 ರೆಫರೆನ್ಸ್ ಆಗಿದೆ ಅವ್ರಿಗೆ ಅವಾರ್ಡ್ ಪಾಸ್ ಆದ್ರು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ ಒಂದು 10 ವರ್ಷ ಬಿಟ್ಬಿಟ್ಟು. ಅದರಲ್ಲಿ ಆ 4 ಜನದಲ್ಲಿ ಇಬ್ರುದು ಅಲೋ ಆಗುತ್ತೆ, ಇನ್ನಿಬ್ರುದು ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ. ಯಾವ್ದು 54 ಅಪೀಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್, ಅಪೀಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ಇಬ್ರುದು ಫೈನಾನ್ಸ್ ಓಕೆ ಆಗುತ್ತೆ, ಇನ್ನಿಬ್ರುದು ಡಿಸ್ಮಿಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ.
ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಅವ್ರು ಯಾರ್ದು ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಎಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಇಸ್ ನಾಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಓಕೆ, ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಅವರು ರೀಡಿಟರ್ಮಿನೇಷನ್ ಕೇಳಕ್ ಬರುತ್ತೆ. ದಟ್ ಈಸ್ ದಿ ಲಾ ಲೇಡ್ ಡೌನ್ ಇನ್ ಹನ್ಸೋಲಿ ದೇವಿ. ನೀವು ಅದನ್ನ ಓದಿ, ಅದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ದೆ ನೀವು ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ರೆ ಆಗಲ್ಲ. Hansoli Devi is a 2002 judgment and that still holds the field, and the learned single judge has referred to Hansoli Devi in deciding these batch of petition.
ಅಂಜು ಅವರೇ,
right,
ನೀವು ಆ
sir.
ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ರಲ್ಲ, ಅದನ್ನ ಒಂದ್ಸತಿ ಓದಿ, ನಿಮ್ಗೆ ಏನಾದ್ರು
Okay,
ಕ್ಲಾರಿಟಿ
sir.
ಇಲ್ಲ ಅಂತಂದ್ರೆ ಆಮೇಲಿಂದ ನೀವು ನಮ್ಮನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಹೇಳ್ತೀವಿ, ಆಯ್ತಲ್ಲ. ಇದು
ಹಾ,
ಬೇರೆ ಯಾವುದೇ
ಹಾ.
ರೀತಿಯಲ್ಲಿ ನೀವು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಅಂತಾಗ ನಿಮ್ಗೆ ಕ್ಲಾರಿಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ಅಷ್ಟೇನೆ, ಅರ್ಥ
ಸರ್
ಆಯ್ತಲ್ಲ.
ದಯವಿಟ್ಟು ಫೋನ್ ನಂಬರ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ಕೆ ನಂಬರ್ ಸರ್.
ಅದು ಇವತ್ತಿಂದು ಲಾಗಿನ್ ಐಡಿ ಇದೆಯಲ್ಲ, ಅದು ನನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ನಂಬರು. ಇದು ಕೇವಲ
Right, sir.
ನೀವು ಪ್ರಶ್ನೆ ಕೇಳೋದಿಕ್ಕೆ ಅಷ್ಟೇನೆ, ಆಯ್ತಲ್ಲ. ಬೇರೆ ಇನ್ಯಾವ
Okay,
ಅರ್ಥದಲ್ಲೂ ನೀವು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿಲ್ಲ.
ಆಯ್ತು ಸರ್. ಓಕೆ ಓಕೆ ಓಕೆ
Sir,
ಸರ್.
with
ಥ್ಯಾಂಕ್
that,
ಯು ಥ್ಯಾಂಕ್
sir,
ಯು.
I think on
Yes,
a
we'll wind up.
positive note, we'll log off today's session. Sir,
Yes.
once again, many thanks to you.
Thank you.
Thank you.
Okay. Good night.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು
Good night.
ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.